Hey, good morning, my people. What's up? Hope and trust that all is going good. I'm good, feeling good. Today is what, Thursday? Thursday, the 21st day of May 2026, and the time is 7 minutes after the 9 a.m. hour. 7 minutes after 9, and boy, this month is flying by. Well, there's a term that we hear used all the while. Destroyer Senior sang a song about it. I don't know if the name of the song was Justice Delayed is Justice Denied. He sang it a few years ago. But I went to look on that. Having read a story, I'm going to get to the story now. I went to look at that. Justice delayed is justice denied is a legal maxim, meaning that if a legal remedy or resolution comes too late, it is effectively the same as having no justice at all. A delayed verdict or settlement can render the outcome meaningless, as prolonged proceeding often cause suffering, degrade evidence, and erode public trust. So let me go over that again. Justice delayed is justice denied is a legal maxim, meaning that if a legal remedy or resolution comes too late, it is effectively the same as having no justice at all. A delayed verdict or settlement can render the outcome meaningless, as prolonged proceedings often cause further suffering, degrade evidence, and erode public trust. And to continue my reading a little bit longer, core reasons behind the maxim: ineffectiveness of remedy. If a wronged party waits years to receive compensation, the money may no longer be enough to fix the original harm or restore their livelihood. Right? No. Why did I read that? I heard of this matter, and I'm just seeing it in the newspaper now, and I'll read it into the record. No, Dave, I'll just read it, sorry, not into the record, meaning quote. So that you have an idea. Appeals court overturned EC 176,500 award against Digicel. The Court of Appeal has overturned an industrial court ruling that ordered Digicel to pay EC 176,500 to former employee Carl Skeppel, finding the company was denied a fair hearing. In a judgment delivered on 19 May, the appeal court set aside Industrial Court September 2023. So that is now 23. So let's call that 2+ years, right? The appeals court put aside Industrial Court judgment, September 2023 decision, and ordered the matter be reheard before a differently constituted tribunal. Skeppel filed an unfair dismissal claim in 2016, right? So let's do the math as we go along. So 2016 to 2023 is 4 and 3, 7 years. 2 years between 2 years between when the industrial court heard it and when the appeals court heard it, between when the industrial court heard it and when the appeals court heard it. It's 2 years between there. So we're talking about 16 to 23, 7, and 23 to now 26. Call it 2. So we're talking about 10 years. 10 years. What's my name? Skeppel. Some Skeppel. Have been waiting to get his or her his justice. All right. So Skeppel filed an unfair dismissal claim in 2016 after he was dismissed by Digicel in August 2015. Over, because you can add 1 more year to that. Over allegations that he made inappropriate sexual advances towards a colleague. Following a discipline hearing, the company said it accepted the allegations and terminated his employment. The industrial court later ruled in Skeppel's favor after proceeding with the hearing in the absence of Digicel attorney and any company representative. Let me just read what it there. The court awarded compensation totaling $176,500, including damages for loss of earnings and unfair dismissal. Digicel appealed, arguing that the tribunal breached its constitutional right to a fair hearing after refusing a request for an adjournment. The company's attorney had cited scheduling conflicts in the High Court and said he was given only 5 days clear notice of the hearing. The appeal court found the industrial court failed to properly consider the reasons for the adjournment request and focused instead on whether opposing counsel consented to it. While the appeal court criticized Digicel for repeatedly failing to file witness statements, let me keep that highlighted. I'm going to come back to that. While the appeal court criticized Digicel for repeatedly failing to file witness statements, it said those shortcomings did not remove the company's right to cross-examine witnesses or make legal submission. The right to legal representation and the right to be heard are fundamental entitlements, right? The right to legal representation and the right to be heard are fundamental entitlements, the judgment stated. The matter has now been sent back to the industrial court for a new hearing. Now, let me just go on record from the beginning and say, I think I would have said it before, but I don't know if in my lifetime I can ever vote for the Caribbean Court of Justice as our final court of appeal. I don't know that I could ever do that. I don't know I could do it. And you might ask, what's the connection? To the best of my knowledge, judges who sit on the Court of Appeal are in the pool to sit on the CCJ. Somebody can correct me if I'm wrong. I have no confidence in them. And I'll tell you why. This is my constitutional right to speak, and this is what I'm saying. Now, as far as I know, when a matter is filed before the industrial court, there's 3 documents that I normally start with in filing before industrial court. You file the reference, the conciliation certificate, and the memorandum. Some people don't file the memorandum initially. Some people just file the reference and the conciliation certificate. I file the memorandum also. Why? It cuts down the response time. Once you file that in the court, the employer has 21 days. I should have pulled up my time, but 21 days to respond to your filing, right? Because once you file in industrial court, you have to serve it on the other side. So they know what's happening. And then once you would have served it on them, then whoever you get to serve it for you, they will go to the court and file an affidavit of service so that the court record is updated. All right. Now, that other side have 21 days to respond. Now, this is all in the rules of the court now. This is in the rules of the court. Let's assume that they file their memorandum on time, within the time frame. Both sides then have 14 days, if I'm not mistaken, to then file their witness statements. And the same thing happened. You file, you serve, affidavit of service. So the court is updated as to what is happening. Right? All right. Now, if you don't file, what we would then do is to make an application for an ex parte trial. That is, the matter is heard. You're applying to the court for the matter to be heard, one side. And again, you file, you serve on the other side, affidavit of service. Right? So the other side knows what's happening. Normally, if they're out of time and they have not applied for no extension of time, they have to come to court. The court hear them based on the application. And if the court accepts the argument, then they would normally charge them costs for the day. Right? If the application is not successful, it's not successful. The point I'm making is, when I hear, or when I read, I should say, that the industrial, now when there's a party where they said the Court of Appeal found, no, not the party there. There's a party that says, yes, while the appeal court criticized Digicel for repeatedly failing to file witness statements. It said those shortcomings did not remove the company's right to cross-examine witnesses or make legal submission. So, Digicel, through its representative, have a duty under the rules of the court to submit the witness statements. And according to this article, they failed on numerous occasions. So, I don't know. Well, if it was me representing the employee, I would have filed for an ex parte trial a long time. So I don't know what happened between there, whether they asked for extension of time, they did not then meet the extension of time, they asked for extension again. I don't know. But what I do know, that how the employer, through its representative, behaved, it could not have been consistent with the rules of the court. Could not have been. Okay. So the appeals court is telling me about Digicel. But what happened to the employee? The employee no have a right to? The employee no want justice to? So a lawyer can just do as they like, a big company can just do as they like, irrespective of the rules of the court. And that is right. We're supposed to accept that. Boy, this country. Right? Well, apparently, I would assume, no, let me not assume. You know what I should do? I should go and look for this judgment here. I'll do that. I'll go and look for this judgment. Because I want to know if the matter was heard one side or maybe the judge came in another time. But it's wrong. When this person was fired in, when they say 2023? No, the judgment was in 2023. And I think the person was fired a year before, if I'm not mistaken. Right? I mean, what is so hard? Look, I know the process. Before a matter comes up for trial, right? Assuming that all the filings are in, the questionnaire is done, you then have case management. And the court will send out a provisional list with suggested dates, right? And lawyers and them will say, yes, based on their diary, yes, we can, no, we can. Then you come down to a final list. And yes, things happen if you have a final list. So you would write to the court if whatever the case is. Yes, I can understand that. There's an issue that I have with some lawyers in this country. You can imagine. Okay, state insurance. State insurance is in the news right now with a matter with a lady who got judgment against them. I can tell you, the matter was scheduled for a Monday. I think it was a Monday. I don't remember the date offhand. And it might have been the very same Monday that the date of the trial, that the court was advised that, the employer side is not ready to go. I have asked some questions. I know why. It wasn't the fault of the legal representative. I can say that comfortably. The employee in question had to travel from overseas to come to and deal with the case. And it's the Monday. So what happened? The court ruled state insurance had to pay damages, and not damages, costs. And along with other expenses, some other expenses, right? So even before the matter was started, state may don't pay. That's a fact. I'm just saying how some of these lawyers operate. The industrial court is going to give deference to or considerations, take into consideration if a lawyer has a matter at the quote unquote higher court, the high court, the appeals court, etc. But generally speaking, and you can ask anybody who operates in the industrial court, lawyers don't believe they can do as they like. Some lawyers, sorry, not all lawyers. They just believe that they can do as they like. So now the appeals court, and I'm gonna say it like they knock one head. It comes across sometimes as if they knock one head. That's just how I see it. And that is my right to say it, and I'm saying it. I mean, come on. You go 10 years gone. Now this person has to go back unless they appeal the appeals court ruling to the Privy Council. Right? then this goes back to the industrial court for hearing. When they're going to get a date again, you don't know. It might be in another year, might be another 2 years. And then what I'm to the employee? Not to talk about the cost that's going to be involved. If they don't meet the lawyer, if they don't meet the lawyer who sometimes have a good heart and look at the cost and deal with it in whichever way they can. It's wrong. It's wrong. I believe it in myself that you can't tell me. Oh, and from what I know of it, I can't see how you get to the stage of a trial and both sides don't know what going on, because for the process that I know, you have to go through case management. You have to go through case management. And then you go come and tell me that you get 5 days. And I say go. That's not the process. And then the same article tell you that the employer, maybe because they're big, maybe because they're big, you fail to file and serve. Because if you don't file, you can't serve. Your witness statements in them on many occasions. When the witness statement is upon which you're going to be cross-examined. No, man. You see, and that's why you see. Well, I recognize to myself that to whom much is given, much is expected. And some people might not understand the importance as to what I'm speaking to. But I do know that there's others who understand clearly what I'm saying. Clearly what I'm saying. A matter goes before the industrial court. If you can get a matter that is filed before the industrial court heard under a year and a half, you do good. You do good. And I'm not talking about the cost involved. You have to go to a lawyer. I'm not talking about that. Just look at the dates in him. Kat, he had a matter the other day. Look at his dates. He was out of the court for a good maybe 2 years, 3 years going there. Income stream messed up. Well, I will keep crying, even if it's one voice in the wilderness for justice. I will keep crying for justice, because justice delayed is really and truly justice denied, as I read earlier. And you almost go and listen to this tune from Destroyer Senior. He sang a tune in that. Justice delayed is justice denied. My people, have a good day. Until we come together again, bless up.